Diamond Media, television reinvented.
Good evening. Thank you so much for joining us for this special program. I'm your host. My name is Andrew Mwansa. Now, the Zambian government recently announced a historical decision to broadcast live constitutional court proceedings before, with the highly anticipated judgment on former President Edgar Lungu's eligibility case. This is a landmark hearing that is set for the 10th of December 2024. Now, Diamond TV will be broadcasting this court proceeding live, and as a build-up to this, we have dedicated 90 minutes of airtime space daily to analyze cases that have been brought before the Constitutional Court. We start the countdown tonight, Friday, the 6th of December 2024, leading up to the Judgment Day that is on Tuesday, the 10th of December. Now, this program will feature insightful panel discussions with experts from diverse fields, including legal professionals, church representatives, and civil society organizations. And on tonight's edition of this program, we're going to be having particular attention to the Danny Pule case, which happened to be the first case that was brought before the Constitutional Court. And we'll look at some of the arguments that were brought before the Constitutional Court, but also what the Constitutional Court did rule in this case. On tonight's edition of this program, I'm privileged to be joined in by a panel of legal experts, and these include George Chisanga, who is the former Law Association of Zambia president, as well as a lawyer. Good evening. Thank you so much for joining us, Mr. Chisanga.
Good evening, Andrew. Thank you very much.
We're also privileged to be joined in by Mr. McQUEEN Zenzo, Zaza. Thank you so much, Counsel, for joining us tonight.
Good evening, Andrew.
We're also privileged to be joined in by another lawyer in Siatwambo. Counsel, thank you so much for joining us tonight on this program.
And good evening, Andrew.
Well, gentlemen, before we can get into the nitty-gritties of our discussion of this program, obviously looking at the Danny Pule case, I would like for us to begin off with your reaction to the decision that government has made to ensure that they broadcast some of the, court proceedings that are of national interest. And I'll begin with you, Honorable George Chisanga, on your reaction to this announcement from the Judicial.
I'm so grateful for the opportunity, but let me disappoint you by telling you immediately that I'm not going to make any comments regarding that decision, purely because of what transpired during the day, the presser, and because of the development that took place after the presser. I've carpeted myself. I need to get into certain engagements with certain people before I can take a position on that matter. So I'll leave it to my colleagues to give their views on that position.
Councillor McQUEEN,
if you permit me.
Councillor McQUEEN, your reaction to this landmark decision, obviously the first time in the history of our country that now people will have an opportunity to hear for themselves what happens in court.
I think it's a welcome move, and it's a very, very good decision in the sense that it's going to make at least our courts accountable, the lawyers accountable to certain derailments. People will be able to know who is causing those derailments. Is it the court or the lawyers? Because most of the time we blame the courts, yet the lawyers are the ones who go to court and ask for these derailments. So I think this is a plus. At least our people in the rural areas will be able to see this case, will be able to hear the judgment, and will be able to be part of the justice system of Zambia. By listening and participating, it's also a good thing to our citizens.
Council Elijah Siatwambo, your reaction to this? Is it shocking that now, for the first time, the people are going to watch the proceedings from home?
First of all, in my opinion, it's the step in the right direction. Because, I mean, people need to be able to, to follow, especially a matter of this nature. This is a matter that involves national interest. And because it's a matter that involves national interest, what happens then, every Zambian is affected by such a decision, So at the end of it all, people need to be able to follow and be able also to see that, there is transparency in the justice system. And my hope that it's just not basically this first case only, but just this is the beginning, of the judiciary, televising, most of the cases of public nature so that members of the public could be able to, to follow. For me, it's a welcome move and it's a step in the right direction.
So much to unpack, gentlemen, on our program tonight. But obviously, like I communicated earlier on, our focus tonight is on the Danny Pule case that was brought before the Constitutional Court in 2017. And I'd like to begin off this, program with you, Honorable George Chisanga, on
Andrew, you were pointing me out.
Given a historical background to what prompted, the applicants to take this matter before the Constitutional Court. Obviously, this is Danny Pule and 3 others that took the matter of eligibility of President Edgar Lungu before the Constitutional Court. Perhaps let's begin off with the historical background. Obviously, people must understand that there was a president that was sitting in who died in 2014 that prompted us to have a by-election in 2015. And President Lungu served between 2015 and 2016. Again, we had an election in 2016 up until 2021. But give us a historical background of what prompted the applicant.
Okay. The starting point is basically to point out what transpired. The most important part of this is what transpired in 2016. We had a different constitutional order before 2016, which allowed for a by-election to take place after the president dies in office. Zambians have been expressing views for the longest time that it is very costly to have a presidential by-election. And we should undertake a constitutional review process that should result in having a seamless transition of power between a sitting president and a sitting vice president when the president dies in office. In fact, these views were expressed even before a number of constitutional review commissions that took place in the country. People expressed this view, but it never got itself into the statute until the Patriotic Front got into power. The campaign by the Patriotic Front, among other things, was to undertake a constitutional review process that was going to take a slightly different dimension because that promised that, rather than do a full-blown constitutional review program which required for the commissioners to go around the country and collect views about what people would like to see in the Constitution, the thinking was that there had been too much literature around in the country which encapsulated what should go into the Constitution. So in their manifesto, they had indicated that they were going to put up a task force that was going, or a committee that was going to go around, look at what has been collected and then draw up a roadmap that takes that material on board and then reduces it into what was called a people's draft. So all these clauses regarding, succession in the office of a president found themselves now in the people's draft and ultimately into the Constitution. So that what we now had was, unfortunately, the president dying in office, President Michael Sata, and being succeeded via by-election by the president, Edgar Chagwa. During the same period, we then had to complete the process of amending or enacting, or rather amending the Constitution by Act number 2 of 2016, which has all these clauses and that have come to the fore in the cases that came to court, where they had to determine the eligibility of the president who was then sitting in office. So this is a little background that we have.
And obviously, quickly to 2017, Danny Pule and 3 others do take this matter before the Constitutional Court. And for the avoidance of doubt, let's quickly look at the screen to ascertain exactly what were some of the questions that were asked by Danny Pule and colleagues that they wanted the Constitutional Court to determine. And this is on page 5 of this particular ruling. Let's quickly get to the question that were being asked. The question that was being asked by Danny Pule and his colleagues was, quickly, if we could get to the question that were being asked. The first question that was being asked by Danny Pule on the screen there is whether His Excellency President Edgar Chagwa Lungu will have served 2 full terms for purposes of Article 106, Part 3, as read with Article 106, Part 6 of the Constitution of Zambia at the expiry of his current term. The other question that was asked by Danny Pule and colleagues were whether, as a matter of constitutional law of the Republic of Zambia, His Excellency President Edgar Chagwa Lungu is eligible for election as president for another 5-year term following his current term of office, which commenced on 13th September 2016. These were the questions that were being asked. And let me come to you, Council Zaza. How important were these questions that were brought before the Constitutional Court?
Okay, to start with, you see, those questions were questions of interpretation. They were asking court to interpret based on the election that had already taken place in 2015. Remember, in 2015, Edgar Chagwa Lungu was elected president after the demise of Mr. Michael Sata. So, according to the pre-constitution amendment, before these amendments that we had in 2016, it never mattered whether you've served for 2 weeks or you're remaining with 2 weeks before your term ends. You understand? It never mattered. So if you died 2 weeks before that, there will be a by-election. So the people of Zambia said, oh, no, this is costly. Let's see, change this thing to where if the sitting president dies, you bring in the vice president automatically assumes office. But there are also instances where the vice president could not assume office. Maybe the vice president is sick or something like that. Then there will be an election. A person will be elected. And those are the provisions of Article 106. Yes. But now to come to look at those questions, the questions that Dan Pule and others took to court was an interpretation whether or not Edgar Chagwa Lungu was eligible. Did the court address its mind in determining that judgment to those questions? The answer is no. When you look at that judgment on page 51, the court asked a question.
Page 51, Director.
The court asked a question, which again it answered on its own. So the question that the court asked was more or less an hypothetical question, which was different from the question that those that wanted certain sections to be interpreted. That meant that Edgar Chagwa Lungu in itself, they were not determining the eligibility of, the court was not determining the eligibility of Edgar Chagwa Lungu, but an hypothetical person who would have served a term in 2015 and a term in 2016 after the amendments. So that is the question that the court was answering. It wasn't a question that those litigants took to court. It must be understood very clearly from the word go.
For the avoidance of doubt, perhaps maybe we can get to the question, Director. I think from what I have on my tablet here, and obviously they're going to pop up what is on page 51. On page 51, the ruling says, before we proceed to consider the question posed above, we note that although the applicants argued in their submissions that this matter has been brought pursuant to Article 128, Part 1A, which gives this court jurisdiction to interpret constitutional provisions, the manner the above question has been couched personalizes the issue in that it targets the incumbent president as an individual. We do not encourage this trend because the framing of the questions for this court's interpretation of the constitutional provisions should not target any individual, as it is meant for the general application of the interpretation is binding on every person in the Republic. What we are dealing with in the present case is the office of the president. We, of course, understand the question is of what it ought to have been and what it aims at, namely the office of the president. Obviously, here the Constitutional Court, before I come to you, Council Siatwambo, gets to change the question that was being brought before the court. Why did it change the question?
I think changing is an overstatement. What the court did was not to change the question. The court just rephrased the question. There's a distinction between changing a question and rephrasing a question. The principle that was being addressed is the same principle. But what the court wanted to establish is a scenario where they would come up with what is called a universal precedent, i.e. a decision that just doesn't bind Edgar Chagwa, because at the material time, he was the one who was sitting in the office of a president. So what the court was saying is, let's not individualize this issue. This is a universal question because either Edgar or somebody else will find himself in these circumstances in future, and we need to state a position of what will be applicable to that individual should he find himself in the circumstances similar to where Edgar Chagwa was. And that's why I like what you quoted, because that's what the court clearly says. We do not encourage the trend of personalizing these issues, because framing the question of interpretation of the Constitution should not target an individual, as it is meant for the general application as interpretation, and it is binding on everyone in the Republic. So they converted the question from being an individualistic question to a universal one, because they wanted to come up with a universal precedent. But the issue they were still addressing is, how do you treat under the Constitution somebody that finds himself in the office of a president in the circumstances that President Edgar Chagwa found himself in the office of a president?
Councillor Chambo, do you agree that by rephrasing the question, the Constitutional Court did not answer to the questions that Danny Pule and colleagues asked?
First things first. The role of the court is basically to interpret the law, right? And the question that was posed to the court was to interpret, okay, basically what amounts to a term of office. Now, the judgment itself on page 51, as you have read, what the court avoided doing was to basically just address one person or an individual in answering the question. So what the court decided to do was to try to take a general position, so that at the end of it, because these questions were brought before the court for the court to be able to interpret. Right. Now, also you need to understand that whether we argue whether the court answered the question, whether the court changed the question, but we also need to be able to understand what are the powers of the court. Was the court right or the court was wrong? It was within the powers, because the court felt that there is need to be able to frame the questions rightly, and what they decided to do was rephrase the question so as to give a general answer and a general position rather than targeting an individual. For me, I don't find any harm or any issue in that.
For you, where is the ambiguity in the court rephrasing Councillor Zaza? Where is the ambiguity in the court rephrasing the question that Danny Pule asked?
You see, I'm not saying that there is an ambiguity. What I'm saying is that there was a change of a question. There was a question that was looking at eligibility. Remember, at that particular point, you could not talk about eligibility of someone because it wasn't a point of election. You can only talk about whether someone or not is eligible at a point of election, at a point of nomination. So the question itself was wrong. The question that was asked for interpretation by Dan Pule and others was wrong. But the court changed that question into a hypothetical question, which question is said to bind all of us. Now, it is that same question that was answered, which now lingered in the minds of others, including Edgar Chagwa himself, to thinking that he was eligible to stand as president in 2021. And I will demonstrate why he couldn't be eligible, even if he were to visit common sense. He wasn't going to be eligible.
Yeah. Let's perhaps maybe get to the response that the Constitutional Court, gave and their view over the question that was brought before the Constitutional Court. Director, if we can get to page 1 of this court case. Page 1 says that therefore the question is, what could have been the intention of the legislature on this aspect in relation to the transition arrangements of a presidential term straddling two constitutional regimes? Our firm view is that it could not have been the intention of the legislature not to provide for the period that was served and that straddled two constitutional regimes as to how it should be treated. This is so because, as stated above, a holistic consideration of the relevant provisions in this case will clearly show that the intention is to allow or enable a person who assumes office of president to complete the unexpired period of the term of another president to save a substantial part of the 5-year term of office in order for that term to count as a full term pursuant to Article 106, Part 6 of the Constitution as amended. It follows that the sub-articles in Article 106 cannot be isolated from each other in interpreting the article. As we have already stated above, an interpretation of a constitutional provision that isolates the provisions touching on the same subject is faulty. Therefore, to state that Article 106 3 applies to the term that straddled two constitutional regimes, but that Article 106 Part 6 does not, is to isolate Article 106 Part 3 from the rest of the provisions in Article 106, which is unattainable at law, and is at variance with the tenets of constitutional interpretation, as all the provisions of the tenure of office of the President must be read together. We are of the considered view that the provisions regarding full term must be applied to defining what is meant by twice held office under Article 106 Part 3 in interpreting the provisions of that article. It therefore follows that in the current case, if you can put the case on the screen, Director, it therefore follows that in that current case, the term served which sits astride the pre- and post-2016 constitutional amendments, and having looked at the intention of the legislature, as we have done, and the holistic approach we have taken in interpreting Article 106 of the Constitution in its entirety, our answer to the question that we have rephrased is that the presidential term of the office that ran from 25th of January 2015 to 13th of September 2016 and straddled two constitutional regimes cannot be considered as a full term. As regards the second question posed on the amended originating summons, which is whether the incumbent president is eligible for election as president in 2021 presidential election, our view is that in light of the position that we have taken as regards to the first question posed in the amended originating summons, the second question has become odious, and we shall not consider it. Since this matter risks serious constitutional issues, it is only fair that each party shall bear its costs. Help us break down, before you react, Councillor Zaza, help us break down an understanding of what the court was trying to communicate here in rendering this judgment.
Zaza or myself?
Yourself.
Okay. In the simplest of terms, what that conclusion says is that if an individual who is sitting in the office of a president was elected under an old constitutional order, I will not call it regime, the court called it regime, I will call it a constitutional order, and then there's a transition from an old constitutional order to the new constitutional order. That's why they use the term straddles between two constitutional orders. So long as that person had remained in office for less than 3 years, that person should not be considered to have served a term. So that in the calculation of the mathematics that the court was employing, in fact, somewhere in the judgment they even say it, is that if, in the case of, let me try and put Edgar Lungu in, so that, because he's a person who was in that position. He's a person who found himself between two constitutional orders straddling between themselves. If a person finds himself in the circumstances where Edgar Lungu remained in office, the only time where you would attribute his first term to a full term is if it can be demonstrated that he had succeeded the dead president and had remained in office for 3 years. But if he served for a period that doesn't go beyond 3 years, that term should not be credited to him as a first term. So that when he comes now recontest the election, that is when you need to start calculating his term as a first term. This is just pure common sense. You see, the beauty about law is that people are going to use jargons all over the place, but you can reduce it to something that is as simple as just establishing what was the intention of the legislature when they were enacting this law. And if you see the interpretation that the Constitutional Court gave to Article 106, all of it, not separating it, they came to the conclusion that there's actually a possibility under this Constitution that somebody can serve a period of 8 years and it becomes a full term. And somebody can likewise serve a period of 13 years and it can be a full term, purely because they took clauses within Article 106 that created what a term is and then related it to what it meant to be twice elected into office. And in their joint interpretation of these clauses, and you rightly pointed out, because they actually say, don't isolate these clauses when you're interpreting a constitution. They then came to the conclusion that in those circumstances, whatever period Edgar Lungu served, which was between 25 January 2015 and 13 September 2016, is less than 3 years, and therefore cannot be attributed to him as a full term. And that's why they concluded that a person who finds himself in those circumstances would be eligible to contest 2021.
You're about to demonstrate to us, Council Zaza, on how the Constitutional Court didn't answer this question.
Okay. The basic understanding of what was happening there was that we should first look at what was obtaining before the amendments. Before the amendments in 2016, first and foremost, we need first to understand that the constitution at play is the 1991 constitution. And this 1991 constitution has gone through a number of amendments. One of the amendments was in 1996 and 2016. So before 2016, what was obtaining was that if you serve or you are elected today and you die 2 weeks, for example, before your term ends, the person who is going to come is going to be president for only how many weeks? 2 weeks. That's all.
The remainder of your term.
The remainder, the expired remainder of the term. This is exactly what Edgar Jagalongo did. He served this country for 18 months. Before the amendments, that 18 months was regarded as a term. And remember, this is the same 18 months where he even became the most richest person. He became richer in 18 months. And this is the same 18 months today he wants to say, I didn't serve as president. If that is the case, then therefore, so that period of time, before these amendments, that was regarded as a term, a full term. So he served as a term. Now, when we look at constitutional amendments do not by themselves apply retroactive. You cannot apply them
retrospectively.
Or retrospectively.
Yes.
You understand? For them to apply retrospectively, you need to have a deliberate article in the Constitution to say that they will apply retrospectively. Failure to which they will not apply retrospectively. Now, when you look at Article 106, Article 106, we are not even going to talk about the legislature because the Constitution is not a document of the legislature.
For the avoidance of doubt, I have Article 106 here.
Yes. When you look at Article 106, it uses two things. It uses the word term in Article 106.1, and it uses hold office in Article 1066, 1063. Now, what is the distinction between a term and hold office? A term means 5 years. It's agreed. The term is 5 years. But the Constitution goes to say hold office or held office. To hold office or held office means you are sworn into office as president. And that period is for the period when you are sworn in to the period the next president comes in. Now, for Edgar Jagalongo to qualify under Article 106.6b, he needed to demonstrate that, one, he was the vice president. So there was a vice president in the country. You understand? Let's assume that those Article 106 applies retrospectively to Edgar Jagalongo. He needed to demonstrate for him to be satisfied or for him to qualify under Article 106. He needs to show that, you look at Article 106, Clause 6b, he needed first to satisfy the Constitution that, one, there was a vice president, and this vice president was unable to take up office. Since this vice president was unable to take up office, an election ensued. Now, let's go back to 2015. Was there a vice president in the country? Yes, there was a vice president. Who was the vice president? Guy Scott. Did Guy Scott fail to assume office automatically? The answer is no. because those applications of Article 106 do not apply. So that's the reason why Edgar Jagwarungu could not qualify, even if we were to argue that those provisions applied retrospective. You understand? Because the condition precedent to him being elected are different from what is envisaged in Article 106.
Let me come to Article 106, Council Siatwambo. Sure. Article 106, for the avoidance of doubt on those that are following, says, Part 1 says the term of office for a president is 5 years, which shall run concurrently with the term of parliament, except that the term of office of president shall expire when the president-elect assumes office in accordance with Article 105. Part 2, the president shall hold office from the date the president-elect is sworn into office and ending on the date the next president-elect is into office. 3, a person who has twice held office as president is not eligible for election as president. And I think the confusion began from here. What it means to hold office and to be elected twice. The argument that has been flying around Council Siatwambo is that President Edgar Lungu was elected twice. In 2015, was elected in 2015 and 2016. That technically means that he was elected twice. But the question is, what is the difference between holding office and being elected? And can we say that for a mere fact that he was elected twice, then the next election after being elected twice, did technically knock him out?
All right. Okay, so what we need to understand first is that we need to go back to 2015, right? So in 2015, what was the position if a president dies, right? This is before the amendment, because the amendment came in 2016, right? So in 2015, the position of the law was that if a president dies, right, the person who is elected into office comes to serve the unexpired term. Okay, that president was in office. So according to the Constitution, as at that time, that was considered to be a term between 2015, right? So President Lungu was elected at that particular time. Now, when we come into, now after the amendment, we go now into Article 106. Now, Article 106, first of all, Article 106.1 tells us a term is 5 years, right? So that is not debatable. A term is 5 years, right? So when we come now to, I don't know if you're able to put that on the screen so that maybe our viewers are able to follow.
Yes.
Please do put it on the screen.
Yeah.
So now, Article 106.3 now provides that a person, maybe let me just read it from my phone so that people are able to. Yes, 106.3.
106.3?
Okay. A person who has twice held office as president is not eligible for election as president. So the question now is, what is holding office? Holding office is basically a person being elected into office. As basic as that. If a person has been elected into office, it simply means he is holding office. So the question now that was needed to be determined by the court was not whether he has held the office twice or so. The question is what constituted a term. So this is where now the confusion is. There is the aspect of holding office, and there's aspect now of what constitutes a term. Whether the period that President Lungu was elected after the death of President Michael Sata constituted a term. It's not in dispute that he held office.
But he held office.
It's not in dispute because he was the president of the country at that particular time. Now the question is, did that period constitute to a term that would then now disqualify him, for the other elections that were coming? So basically, that's where the issue is. So it's either holding office twice or whether that period constitutes a term. So that is where the confusion is. So because others definitely will interpret.
Did the Danny Pule case cure this confusion?
Look, that question, whether one says it didn't cure it or it was cured, the question is, what is the position of the law? The position of the law is basically what the court ruled. And what the court ruled is what the position of the law is. Not until whether the court decides to overturn or decides to maintain. So another person will basically say, he that did not constitute a term, that constituted a term. But eventually, there's a decision. And that decision of the court is basically law until now. Not until maybe the court decides to overturn it or not. That's my position.
The position
You
of the
asked
law
a very specific question.
clear,
You asked
counsel.
a question whether the Danny Pule case addressed itself to this issue and resolved it. The Danny Pule case that we're discussing has a conclusion. And in fairness to the judges who decided the Danny Pule case, they went to the lengths of explaining themselves how they drew that conclusion. But what was very pivotal in the Danny Pule case is this understanding, firstly, that constitutional provision must not be read in isolation. You must read constitutional provision in such a way that, a constitution has got a way in which it interprets itself. There's no inconsistency in any constitutional provision. But in trying to come up with the conclusion that they drew, they employed what was called a purposive interpretation of the Constitution. In other words, you must strive as judges to give purpose to the Constitution, because the Constitution is a live document. That's why we call it a grandum. You can't leave it to chance of trying to leave an interpretation this side and an interpretation the other side. But I would challenge you to find time yourself, sit down and read the Danny Pule case. See how these judges apply themselves to that case. They went to the lengths of first talking about the constitutional orders in the country from 1964 to 2016. They explained clearly how the order scenarios did not provide the need for this interpretation that came to give under the Amendment Act of 2016. They realized, that there may have been some little folly, which other people have come to call lacuna, in the 2016 Constitution. But they employed the judicious intellect that they have to give purposeful interpretation to the Constitution, because this is not something they thought they should leave to any chance. And in doing that, they actually read that Constitutional Amendment Act of 2016 together with Act number 1 of 2016, which was almost like a transitional provision. But they concluded that they didn't have any transitional provisions in that Constitution. But beyond that, they utilized the precedents that exists in the country, cited cases like Lewanika versus the MMD, which came to the Constitution, to the Supreme Court, where when the Supreme Court discovered there was some kind of lapses in the constitutional provisions, they put their own interpretation in the Constitution. And this is the power of jurisprudence. This is what the courts are supposed to do. I heard my younger brother, Zaza, suggest, and I hope we can extricate the question of whether Edgar Lungu became rich in 18 months or rich in 50 months or 13 months, and really just discuss the law. Because the law is really what it is. What was central in the case of Danny Pule, versus Attorney General, were two things. Firstly, purposeful interpretation of Article 106 of the Constitution. And secondly, how do you treat the individual that finds himself in the office of a president in the period where there's a straddle between the two constitutional orders? There was a Constitution of 1996 that my younger brother Ebri referred to, and the Constitution of 2016 that we have both referred to. And the court asked itself, how do you treat an individual who finds himself in that scenario? McQUEEN does not agree with the interpretation of the Constitutional Court, because he says that they fell short of dealing with the two issues separately by saying, according to him, if you were a president under the old constitutional order, even if it's 2 days that you serve, it is that 2 days. In fact, they did interpret that clause. They even said under the old constitutional order, I think they cited Article 35, where they clearly say that in that constitutional order, you could only have been president for those period that was remainder. But in addressing themselves to the issue of a constitutional order that stands astride two constitutions, the old constitution and the new constitution, they had to interpret clauses in such a way that they accorded purpose to what is contained in the Constitution, and which is why they decided to, clearly get into the haystack to go and find a clause in Article 1062, 1063, and 1066, which, according to the interpretation, they came to that conclusion that I drew for you, that there's a possibility under the new constitutional order, where somebody can actually be in office for less than 2 years, and you don't for less than 3 years, and you don't credit it to his the first term. But if he stayed for more than 3 years, then let's just say 3 years clear, then you should credit it to his tenure. So that in their interpretation, they even came up with a possibility that it's possible under the new constitutional order that one can be in office for 8 years and he won't be eligible to contest a subsequent election. On the same interpretation, vice versa, they conceive the possibility in interpreting especially 1066, which talks about tenures or terms of a presidency, that one can actually be in office for 13 years under those constitutional orders, because they had to give purposeful interpretation to the clauses that they found had some kind of lacuna in the constitutional order.
And obviously they'll be elected for more than twice if they're in president for 13 years.
You see, when you use the terms twice elected, you are actually splitting hairs. And it moves away from what is called a purposeful interpretation of the Constitution. And that's why for them they merged the two. They dealt first with twice elected, and they also dealt with the term of office. And according to them, in interpreting Article 1066, a term of office has two descriptions in there. One can be either 3 years, and the other can be 5 years.
Actually, I tend to differ with my older brother.
Obviously.
Yes. You see, a constitution is not a document of parliament. It's a document of the people. The views that find themselves in the constitution, they are the views of the people. That must be noted. The views of the people from the 1964, especially after 1991.
It should be 1973. That's when we first the first CRC. 1964, we were given a constitution by the UK.
Anyway, the views of the people.
Yes.
The views of the people has been that they want a president to be elected, what? 2 times. How long? 5 years. So, to find an interpretation that goes far beyond what the views of the people wanted is what I'm saying no to it. The views of the people is that any person should end at 10 years. 10 years should be the highest. 5. Edgar Jagwalungu was first elected in 2015. If he lost that election in 2016, if he lost the election, he would have come back and recontested. But this is a person who's been elected in 2015. In 2015, any remainder was regarded as a term. But when we come to this amendment, after these amendments, for you to qualify, for anything to qualify as a term, it has to be 3 years and above. There is a qualification now. But in the past, there was no such qualification. Anything that you are going to serve after the demise of the president was regarded as a term. There is a difference between a term and to hold office. A term is now qualified to be 5 years, whereas to hold office means you are sworn into office as president, and for the period up to when the next president comes in. And in this regard, to hold office can also mean you can hold office for 5 years. You can also hold office for less than 5 years, which is 3 years. Edgar Jagwalungu held office for 5 years. He held office for 18 months. He does not qualify to again contest. He wasn't even supposed to qualify in 2021 to contest that election, because the circumstances that required him to benefit from Article 106 did not exist at that particular point. His election was not an automatic thing. There was an election because the Constitution provided as such. If those provisions were to apply retrospectively, as I mentioned earlier on, it would have meant that Guy Scott was going to be president and not Edgar Jagwalungu, because Guy Scott was the vice president. But we had a situation where the Constitution, as it was that time, dictated that we needed to have an election.
By-election, yes.
And that's why we had the by-election. After the amendments, the situation changed. There came in the issue of a running mate. So if the president dies, the running mate automatically assumes office. If the running mate doesn't assume office because maybe she's ill or is ill, that's when now you're going to have
or it doesn't qualify
or
under
it
the
doesn't
Constitution.
qualify. No. We can't talk about it doesn't qualify because for you to be a running mate, you need to qualify.
Yes, but just a
but
possibility.
Anyway,
Yes.
the issue, no, there's no such possibility.
Yes.
There's no such possibility anyway. There's no such possibility.
Oh, Guy Scott was restricted to...
No, we're not going to talk about Guy Scott, but we're talking about it.
No, we're actually trying to give a real situation because you said Guy Scott should have been the successor.
Yes. Let him finish.
All right.
So, you will discover that after the amendments, what you needed to trigger those provisions in Article 106, you needed two things to happen. One, automatic assumption of the Vice President. Was Edgar Lungu the Vice President at that particular point? No. It was Guy Scott. So the first tick is out. The second scenario is, if the Vice President is not qualifying, then you are going to have a by-election. Did such a scenario happen? It didn't happen in 2016
Where
because
the Vice President didn't qualify to...
It's 2015.
2015.
It's a different constitutional order.
That's the reason why we are saying those provisions cannot be retrospective. They cannot be applied retrospectively. You understand? Because they needed certain triggers for Edgar Lungu to have assumed office. So our argument, or my argument, is that in 2015, Edgar Lungu was elected president. He held office for that term, 18 months. The same 18 months I've referred to, that's the term that he even became richer. Remember, he came in with 1 point something million. That's what was declared. At the end of the term, for 18 months, he had approximately 27 million. That is the term. That was the term that Edgar Lungu first served. He was first sworn in. The second time Edgar Lungu was sworn in was in 2016. So he's been sworn in twice. In short, he has held office twice.
Councillor Siatwambo, your reaction to this?
Look, like I stated earlier on, right? Did President Lungu hold the office of president twice? The answer is yes. Because he was elected twice. In 2015 and in 2016, right? In 2015, there was one constitutional order which basically defined a term, including that unexpired, term of a president who is deceased. Now, we come to 2016, there is an amendment. Now, when you go now to Article 1066, I don't know if you could put it on the screen. That's where the issue is.
Yeah.
Okay. So now, Article 106, 6. If I could be able just to read it.
Yeah.
Yeah. So Article 106 says, if the president assumes the office of president in accordance with Clause 5A, or a person is elected to the office of president as a result of an election held in accordance with Clause 5B, the president or the president-elect shall serve for the unexpired term of office and be deemed, for the purposes of Clause 3, to have served a full term as president if at the date on which the president assumed office, at least 3 years remaining before the date of the next general election. So the interpretation of
B?
or B, not to have served a full term of office as president if at the date on which the president assumed office less than 3 years before the date of the next general election. Right. So the position here of the Constitution is that if, for example, a person serves, right, assumes office, right, and then serves office maybe for 3 years. Maybe a president dies and assumes office and serves for 3 years. At least that will be constituted a term, right? Okay? And then if a person serves for less than 3 years, for less than, to be specific, not to have served a term of office if at the date on which the president assumed less than 3 years.
3 years, yeah.
That is not constituted, it's not regarded as a term, right? Agreed. Now, the question is, when did this constitution amendment take effect?
2016.
2016. So does it apply retrospectively? That's a bigger question.
Does it?
No. Because the law does not apply retrospective. So it is not in doubt, right? It is not in doubt, according to the amendment in 2016, right?
So the constitution that brought in Edgar Lungu was the 1996 constitution, am I right?
Actually, the constitution that has brought Edgar Lungu twice is the 1991 constitution. It was just amended in 1996. These are just the amendments we're talking about. It's the same constitution.
But look, when
we're talking about amendments that happened before.
When a new constitution amends the previous one.
Help us understand then why we're applying the law retrospectively.
We're not applying the law retrospectively. You see, if you avoid the argument that, or the reasoning that the Constitutional Court applied, when it talked about the need to address a person who finds himself straddled under two constitutional orders. It's a very fundamental question, because that informs what conclusion the court is going to draw. And for them, they went to lengths. That's why I said I challenged you. We don't have the time here. This judgment is about 70 pages thereabout. There's a portion where the court went to lengths explaining the consequences or the implications of the changes in the constitutional orders that took place. But when they got to this individual, they found two challenges. First, they found that, yes, it was brought into office first via by-election, okay? And that he was only going to serve that period from 25th January to 13th September 2016, okay? And then he straddled into a new constitutional order. Okay, and then they have to interpret these terms that I talked about. But what they found themselves doing ingeniously was to see how do we treat an individual who finds himself in those circumstances. And in their assessment, they say that when somebody finds himself in a scenario where he straddles between two constitutional orders, you have to invoke the provisions of Article 106 to deal with the situation as it arose at that time. In fact, this issue of whether the case was maturely before the Constitutional Court or not was raised even in the court itself. And the court said, yes, this case is maturely before us. We are going to deal with it because we're only interpreting the Constitution. Now, you cannot debate this matter without looking at how they reasoned on how to deal with an individual who finds himself straddled between two constitutional orders. And they cited various authorities to support their finding. And they drew this conclusion that you read yourself. It says it therefore follows that in the current case, the term served and which sits astride okay, the pre- and post-2016 constitutional amendment, and having looked at the intention of the legislature as we have done, and the holistic approach we have taken in interpreting 106, and its entirety, our answer to the question that we have rephrased is that the presidential term of office that ran from 25 January 2015 to 13 September 2016 and straddled two constitutional regimes cannot be considered to be a term. That was their conclusion. Now, these are men and women that reviewed constitutional orders. These are men and women that applied themselves to interpretation of the constitutions. These are men and women who compared, drew up a comparative analysis with other jurisdictions where these situations arose, and they drew that conclusion. Now, what we also need to agree...
I don't agree with him when he says...
Let him finish and then...
What we also need to agree with is, look, I was in the state of maze even myself before the decision of the Constitutional Court, because there had been too many interpretations ascribed to what was going on. But as a lawyer who's sworn, by an oath of a constitution, and who has a duty to protect the decision of the Constitutional Court, when the Constitutional Court read this judgment, we became bound. And this is a decision of the Constitutional Court. Mind you, in the constitutional order that we have, all of us as a nation, the whole nation, we have taken a position that those 13 or 11 men that are in the Constitutional Court will be the only ones who will tell us what is constitutional and what is not constitutional. Not to say they are infallible. They are not infallible. I don't agree with the position that they're infallible. But we have, tied ourselves to a covenant as a nation that when it comes to interpreting the Constitution, all of us can have views. McQUEEN has got his own views. Siatwambo has got his own views. Chisanga has got his own views. It's chaos. if we're going to be dragging our views and say, this is what I'm going, I'm going to insist on that position. And then we agreed that, look, yes, we know constitutional power vests in the people of Zambia, but in terms of understanding what is constitutional, we all decided to surrender ourselves and say, those 13 people are the ones who are going to be telling us what is constitutional. And when they make a decision, we are bound. That is constitutional democracy. You may not agree with them.
I wish we could go to the bumpy fallacy because they address some of those issues that you're addressing. But Council Zaza, you seem to be in disagreement.
No, me, I do not agree that, you know, our first duty as lawyers is to the Constitution of Zambia. We sought to protect the Constitution of Zambia. You understand? That is the more reason why, after we read that judgment, we are still saying, we are still going back to court to ask the Constitutional Court to say, can you review this decision based on certain arguments that we've put across, or some of the arguments that I've put across. You see, our duty as lawyers is to the Constitution. There's nothing that is above any other person other than the Constitution. We are all bound as citizens to protect the Constitution. It is your duty to defend the Constitution at any time. So, we are here to defend that Constitution, that the people of Zambia said this is our document. And that's why we are here. So in defending that Constitution, we need to show why we are saying that Edgar Jagwalungu did not qualify. And it's just the truth. Now, when you look at the Daniel Pule case, just look at the lawyers. First, you start first with the parties. When you look at the parties in the Danny Pule case,
let's get to the parties.
Go to the parties.
We need to avoid.
Go to the parties.
We need to avoid personalizing.
No, we are not personalizing. It's the truth. It's the truth. We need to look at it holistically.
Because you see, the flip.
What about the parties?
The flip side.
Listen, let's get here. What about the parties?
If for example, I'll give you an example. If today chickens, both sides, there are chickens this side, and the plaintiffs are chickens and the defendants are chickens. They go and say that no, Christmas will not be allowing people to be eating things. The decision will be such that they will look at the arguments from chickens from both sides, and the decision should be made by what those chickens are saying. Look at the parties from those sides. You will discover that these are ardent supporters of Edgar Jagwalungu.
Of course.
The lawyers are ardent supporters of Edgar Jagwalungu. The Attorney General that side, the then Attorney General Karaluka was a supporter of, was an affiliate of. Then there's also. So this is where the problem.
Let me just make this. Let me just make this point. You know, this point. Let me. Hang on. This point is very important. You see, we can't be drawing ourselves into discussing parties because the converse will also be the case.
That's true.
One will want to argue that those who have gone to court today, are supporters of President Hakainde Hichilema. One will argue that even the Attorney General today was an appointee of Hakainde Hichilema. I think we can keep it on discussing the principles of law that came to the fore during the determination of the matter.
Okay.
I agree that we have a duty, not even a duty, it's called fidelity to the Constitution, but the duty of respect of judicial precedents is also a duty of a lawyer until the court vacates its decision. And that's why I said earlier on, I said that courts are not infallible, okay, but there are also principles of law that are cherished and that have designed what jurisprudence in any given country at any given time is supposed to be. That's an issue that we can discuss subsequently.
We'll be discussing whether it's possible for the Constitutional Court, and it departing from the decision that they've already made.
Let me give my comment on this issue. First things, yes, we swore to the Constitution.
Yeah.
And in addition to that, as lawyers, we are officers of the court.
Yes.
Right? So there are instances where courts would make decisions, right? Because there are always two parties, for and against, to every issue, right? So there are instances where the court makes a decision. Another party, for, maybe will be okay with the decision. The other party will say they are not okay with the decision. But the key issue is this. Whether we agree with the decision of the court or not, at that particular time, the decision of the court remains law until it is reversed, or the court basically changes its position. So they are different. Schools of thought. Others basically say, no, he did hold office twice. Others saying, no, it didn't amount to a term. But the position is that in the Dan Pule case, the Constitutional Court gave a ruling. And that ruling is still binding. So that is why the issue is before the court again. And obviously, those that are not pleased with the decision, they want to basically challenge the decision.
Is it possible, Counsel, that the Constitutional Court can vacate from the earlier decision? And what circumstances could lead them to do that?
First of all, the court has the power to do that. The court has got the power to vacate that particular decision. With regards to the circumstances, I am not in the position to be able to go, because obviously the court will have to look at the arguments that are presented before the court and then look at whether there are special reasons why the court can be able to vacate that particular decision. But as it stands, that decision is basically still what is binding, unless maybe the court decides otherwise.
Counsel Zaza, what could lead potentially to the court departing from the earlier decision? And is it lawful?
Okay, to start with, we are officers of the court, and we've got a duty to protect the Constitution. Whatever decision courts make, they bind us. However, in compelling circumstances, with compelling reasons, courts such as the Supreme Court or the Constitutional Court, which are courts of finality, they can revise, they can reverse or review their decision. In this regard, those who've gone to court, they are asking the court to review their decision, and they've put reasons as to why they should review their decision. And one of the reasons is that probably there were certain things that maybe that question that was asked was not properly asked and could not be properly dealt with at that particular point, because now we have an actual situation. So in having an actual situation, this is how we are looking at things, and it is very lawful. The court has done that. In the Pirira Jere versus Pirira Jere and two others versus Munia Zulu in 2020, I think it was in 2022, a constitutional court. The Constitutional Court of Zambia allowed Munia Zulu to apply so that the court could change its decision on a ruling that the court had made. At that particular point, the court had made a ruling that Munia Zulu could not, he was late in filing certain documents. So the court said, no, we applied to court whether the court could review its decision. The court said, yes, we can review your decision, but your reasons as to why you want us to review your, the decision are weaker. And that's precedent now. That's the law. So the Constitutional Court has demonstrated in the past, in 2022, that it can review its own decisions. And it's lawful. Even right now, it's lawful. So those that are saying that it cannot, they should go and read the Pirila, Gertrude Jere, and the three others versus Munia Zulu case. It's a ruling of the Constitutional Court.
Counsel.
There's a set of principle of law in common law that the final appellate court is not bound by its previous decision. It's a set of principle of law. But I take caution when you have to draw a comparison between what happened in Munia Zulu and Pirira Jere, because you are really talking about a procedural issue where, because of some lapses somewhere, there was a delay in filing process. Courts are motivated by the quest to do justice. Okay, and when somebody demonstrates that the lapse or the delay in filing documents was not deliberate or intentional, or it wasn't meant to and there's need for them to do the greater good to justice, they will allow you to do that. Now, you can't draw that comparison in trying to come and deal with the issue such as of a fundamental importance like this case, where the court made a final determination of how to treat an individual that found himself in the circumstances where Edgar Chagolungu found himself. The principle of law that allows the court not to be bound by its previous decision has been demonstrated in cases over 100 years in common law. But it's always in instances where subsequent cases arise with subsequent parties. There is so much I can say about what is happening in the Constitutional Court, but I think I'm at the wrong audience here. If you give another opportunity, I can discuss those issues to deal with what concerns everybody has with what is going on in the Constitutional Court currently. But I'll tell you that the courts are very rare when it comes to vacating a decision that they made. You have to demonstrate. There's a case of Donoghue versus Stevenson, which is a celebrated case in negligence. That case was undoing a precedent that had been in place for 100 years. They had made a decision 100 years before that, you see, if I'm dealing with you, I only owe you a duty of care. I would never owe him a duty of care. I would never owe him a duty of care. And it remained a precedent for 100 years. That's how conservative the common law system that we are applying in this country is supposed to be. But when it was now demonstrated that, you see, commerce in the UK had thrived, circumstances in the UK had changed, there was need for us to cap up on the duty of care that one owes, not directly to somebody they're dealing with, but somebody they may not have dealt with. The case of Donoghue and Stevenson related to somebody who consumed a drink that had a smell, and they sued a company that manufactured that drink, and that person didn't buy the drink from the manufacturer, bought that drink from a shop. Okay, so there was now issues of how do we deal with the issues of the tort of negligence with all this industry that thrives now. What I'm trying to demonstrate is that the courts are very, very rare when it comes to determining how they can vacate a decision that they themselves made because of the need to have what is called binding precedent, because of the need to have what is called res judicata. When a court makes a decision, it folds its hands and says, look, I have decided, I am moving on. Yes, there must be demonstration. You see, like we have tried to demonstrate here, the Danny Pule case is not the only case that went to the Constitutional Court. Several other cases went there on the same topic. And it is very rare that courts are going to vacate their decisions on the same, with the same parties, you know, the same subject matter. Then you're going to create chaotic situations in the country where everybody who's not satisfied with the case will wake up and say, oh, I never intended it. Let me just go and apply for review. Even review jurisdiction in the High Court or the Constitutional Court, it is very rarely, you know, the discretion is very rarely used because there is need for us to establish binding precedent going forward. Of course, there's so much that is going on in the constitutional democracy in the country. There's so much that's going on in the Constitutional Court to an extent where people have even started questioning the standing of the court. But I have always argued that we cannot throw a baby with water in it. This Constitutional Court is a creature that we put in place only in 2016. We have tried to utilize it for some time. We need to give it time to grow its jurisprudence. Of course, if it makes mistakes, you have to point at them because justice is not a cloistered virtue. But what I have difficulties with is where people are going to be waking up at any time thinking we're going to go back to court. If circumstances change maybe 30% in society, you wake up and say we're going to go back to court. We are not going to allow ourselves to develop as a constitutional democracy in the nation. We need to allow this process to grow. In South Africa, they only reviewed their constitutional court 15 years down the line, into 18 years, because they allowed it to grow. And when they discovered now it has entrenched itself, it's grown, that's when they did a review of the Constitutional Court. But with what we are doing as a nation, you know, we risk ourselves, you know, quite frankly, we are putting the Constitutional Court in the most awkward of positions because, unfortunately, we are driving it with political agendas. And this is not to blame the UPND alone. I think it's to blame every other political player that has done some politics in the country where we think that the court must be part of the political process. It shouldn't. Courts are supposed to be kept very distant from the political process so that we...
You think now they're being used?
Well, look... Like I said, you know, I'm trying to be very cautious, not to stray.
Your concluding remarks, Councillor Zaza, your concluding remarks?
The Constitutional Court, just like the Supreme Court, are courts of final instance. Okay? They can still vacate or depart from their decision in compelling circumstances. That's the law in Zambia. Even in other countries like South Africa, it's the law. They do review, and there's no chaos in South Africa. Why should we now start envision chaos today? Because it's dealing with Edgar Jagwarungu, or the PF are not happy that someone is saying review this decision. There's nothing wrong with that. Even I remember there's a case of Mutembo Nchito versus the Attorney General. It was in the Constitutional Court. He applied to review. And the Constitutional Court reviewed. Was there any chaos? No, there was no chaos. Did you even hear about it? Nothing. So we should not just be imagining things that are not there.
We finished?
Sure. All right, sure. Look, the court, it's settled law. Okay, the court has got the power to review its decision. All right, and litigants who appear before the court have got actually the right to apply to the court for any relief they deem fit, right? But at the end of it all, in making a decision, the court has to look at the reasons that have been advanced. So that power cannot be taken away, from the court, because the court has got the power in it to review decisions. And also litigants have got, be it on the same subject matter, different subject matter, litigants are free to go to court for any reasons. But now it is up to the court to look at the reasons advanced by the litigants, and the court will be able to decide whether to vacate their position or to maintain the position. That is the power given to the Constitutional Court by the Constitution of Zambia.
Concluding remarks, Counsel?
Well, look, I don't want to be predictable, but I just want to insist that when we set out ourselves as a constitutional democracy, we allowed a scenario where the yardstick we set for ourselves for determining what is constitutional or what is not constitutional, we surrendered it to the Constitutional Court. I think all of us, beyond lawyers, because this is a court for the people, beyond lawyers, every citizen, we have a duty to allow this court to grow. We have a duty to allow this court to develop a jurisprudence that helps us, to grow our constitutional democracy. I am a saddened lawyer, come patriot, because I think we have tried to politicize a lot of things that we're doing in this nation, to the extent where we don't even know now how superior the Constitution, for instance, is in relation to politics. We think that politics are much more superior than the Constitution. This is a problem that we're creating for ourselves. And like I said earlier, I don't blame this uniquely on the UPND. It started, I think, with the time we entered into a multi-party set system, because I think our mindset is always to think that politicians are the most important people in the nation, when in fact they are not. There are other important people in society that can drive the agenda of developing a society. But if we are going to continue looking at politicians in the way we used to see them in the UNIP days, we will not thrive as a democracy. We need to allow the Constitutional Court to entrench itself.
Counsel George Chisanga, thank you so much for making time to speak to Zambians tonight.
I'm grateful, thank you.
Counsel McQUEEN, Zenzo, Zaza, thank you so much for making time to speak to the Zambians tonight. Counsel Siatwambo, thank you so much for making time to speak to the Zambians tonight.
Thank you so much.
Well, there you have it. We'll continue tomorrow. Tomorrow we focus on the Bumpy Kapalasa case, and then on Sunday with Costa we focus on the Legal Resource Foundation case that also Siatwambo was part of this case, that they took to the Constitutional Court for the interpretation of Edgar Lungu's eligibility to contest the 2021 elections. On Monday, we feature the petitioner himself, Siatwambo, as we understand some of the reasons he advanced before the Constitutional Court. Also, we look at submissions that are before the Constitutional Court in the Chizombe case. On behalf of the entire production crew, thank you so much for watching. See you again tomorrow at exactly 21:15 as we continue with the countdown of the Edgar Lungu eligibility case that comes up on the 10th of December 2024, and Diamond TV is part of the television stations that are broadcasting this live. Good night.
The ZNBS fixed deposit account is the key to unlocking your financial potential. With competitive interest rates and the ability to choose a tenure that fits your needs, you can ensure that your money is working hard for you. Whether you're saving for a rainy day, a dream vacation, or even retirement, the fixed deposit account guarantees that your money will grow at a steady rate, giving you peace of mind and security for your future.